The SAFE Act. What does that all mean? Why is it so controversial? But did you know that there was something before the SAFE Act that was even more controversial? And it may be headed to the Supreme Court. Stay with us in the moment as the state of Greater Western New York talks about it. And it's brought to you by...
Imagine yourself communicating with a difference. Pan-Dimensional Solutions helps you do this. Whether live spectator events, taped broadcasts, or real-time audience-engaging programs, you can benefit immediately from the tools Pan-Dimensional Solutions will share with you. Do you want to make a difference? Contact us at pandimensional.com. Welcome, everyone, to this edition of the State of Greater Western New York Report. Join us each episode as we discuss fantastic topics ranging from history to science to the strange and the wonderful, as well as the treasured spirit with which our region has infused America. We challenge you to consider all things Greater Western New York, from our region's very beginnings to how it inspires, how it empowers, and why it is so admired. Here's the host of the State of Greater Western New York Report, Chris Carosa.
Hey, everybody, and welcome again to this week's version of the State of Greater Western New York Report. I'm Chris Carosa, your host, and with us we have two excellent guests who will be talking about a very interesting topic that may be finding its way very soon to the United States Supreme Court. With me are two people that are very, very interesting. We have Duane J. Whitmer, who's the chairman of the Erie County Libertarian Party, and James Ostrowski, who's an attorney who will talk more about the case. First, let's start with Duane. Duane, can you give us a little bit of background on maybe what was going on in New York? What is this issue and how it really predates the SAFE Act?
Yes. So if you are a gun owner in New York State and you attempt to get a pistol permit, you first of all have to ask permission from a sheriff and a judge to exercise the right to defend yourself, which is absolutely asinine to begin with. But if you look at each county, I'll use myself as an example. I got my pistol permit in Chautauqua County. In Chautauqua County, it was a couple references. You take a class, you submit your paperwork. 3 to 4 weeks, you get your permit, and you're good to go. I've since moved to Erie County, and transferring my pistol permit from Chautauqua County to Erie County, just transferring it was almost impossible. There's real inconsistencies between county and county. There's New York City. Good luck getting one down there. We've had a lot of issues with people in New York City not being able to get a permit, especially in a place like New York City where there's a lot of shootings, a lot of crime, a lot of violence. Especially after this summer, there was rioting, there was protesting, there was looting. Your right to defend yourself in public should be, easier to obtain, especially as that happens. And then another underlying issue with the pistol permitting regime is how they accept or deny people. It's the progressives like to talk about systematic racism. Statistically speaking, if you have an ethnic or foreign sounding name, you're more likely to get denied. So there's a lot of underlying issues with actually getting the pistol permit in New York State anyways. So this lawsuit started pre-SAFE Act, and then when the SAFE Act came out, we decided to do something to attack, gun control in New York State. There was already a pending lawsuit challenging the SAFE Act, so we shifted from that to the pistol permit regime, and here we are. I don't know if you have any questions for me or anything you want to ask as far as, what made us want to do this, or information.
I actually was fumbling my fingers, which is why you saw your name appear twice on the thing. This is great. This is live, folks, and we've got an audience here that I was just paying attention to. So if you have a question, feel free to put it in the chat. But let's talk, Duane, again, let me ask you a follow-up question on that. Tell us a little bit about what you saw at the time. Now, this is going back towards the era when the SAFE Act came around. How did the emergence of the SAFE Act sort of bring more people involved in this process, got more people interested in the existing case that you had?
So the SAFE Act turned me into a felon overnight. I'm an accountant. I was, when the Safe Act came out, 8 years ago, I was 25. I was an accountant. I had a college education. I wasn't doing anything illegal. And because I owned firearms that some nobody bureaucrat deemed scary, they outlawed these types of weapons and turned us into overnight felons. So people were a little upset because um, there were a lot of people who have no criminal record, have no history of doing anything illegal, are now considered outlaws according to New York State guidelines. And so you got a lot of people fired up from that because they don't want to go to jail, because at the time when the Safe Act first came out, actually, a standard capacity Glock magazine for my Glock, I carry a Glock 19 and 40 caliber. The standard 10 round magazine, there was a 7 round limit. So the asinine Safe Act said you can only have 7 rounds in a 10 round magazine. Well, who's counting that? What's the rule on that? And then when the Safe Act first came out, with that 7 round limit, the punishment for having more than 7 rounds in your magazine was actually worse than forcible touching of a child under 12 years old or something like that. So I was kind of confused as a gun owner at the time, because there is no victim in having 8 rounds or 9 rounds in a 10 round magazine. There is a victim with forcible touching of a child. So it was another victimless crime on the books. That, how do you enforce that? It made no sense. And as the Safe Act has progressed, I'd like to point out that the Safe Act has done nothing to impact violent gun crimes. Gun crimes were dropping before the Safe Act, and they're dropping at the same rate post Safe Act. So there's absolutely no impact on violent crimes. All the Safe Act has done well in New York State is be used as a additional charge to put minorities in jail. I believe if you look at the statistics in New York City and upstate New York, 92% of arrests under the Safe Act are non-whites and minorities. So what essentially is happening is you have the insane war on drugs and the war on poverty in the state. You catch someone doing something illegal, to add to the charges to get them in prison longer, you get them on a gun charge. That's not helping society do better. It's further perpetuating the violence and the issues we have in this state. The Safe Act has been an insurmountable failure, and you can statistically prove it. So,
Well, what I'm kind of curious of, how did a law come into effect that had somebody who wasn't doing anything illegal initially all of a sudden do something legal without actually changing anything? I mean, isn't there some sort of grandfather clause, or wasn't there a grandfather clause? And why wasn't there if there isn't?
There is, but you had to register. I believe you had to register your non-compliant rifles, which for any federal officers watching, I totally did that, please. But yeah, there was some ways around it. You had to do certain things, but it was the system was down for a bit. They weren't ready for it, and 98% of people just didn't register. Good for them. You shouldn't have to. I question why there's a registration of firearms. I don't think you should know who has firearms and who doesn't. For security purposes, if there's a list of who has firearms and who doesn't, if you can foil that list and get access to who has what, there's your shopping list for a potential criminal right there. The unintended consequence of that is a little terrifying. But yeah, there were a couple things you could do. You had to. They told you that, I believe this is like 10 years ago now, so pardon me if I might be incorrect, but I believe they said you had to either register them, get rid of them, or sell them by a certain time. But like I said, a lot of people didn't. And then with the 10-round limit, now the 10-round limit was struck down, or the 7-round limit was struck down. Thank God they did something right. But you really can't enforce that, because most, like I said, my Glock comes with a standard 10-round magazine. They don't make 7-round magazines for it. So a lot of the laws that they put in place, compliance was difficult, and confusing. Same thing with renewing your pistol permit. Every couple of years you had to do something to renew your permit. And it's hard to do if you're elderly, if you don't have access to computers, or you're not computer technology savvy. So there were a lot of issues with that too.
So when you talk about non-compliance, if I recall correctly, and maybe you can elaborate on this, the law was actually very controversial, and even some sheriff authorities in various counties, didn't they say that they weren't going to enforce certain aspects of it because it impacted them as well? I think that's the way the law was written, is that even the police were subject to this law. And that tell us a little bit what you remember about that.
I don't remember that. I know a lot of sheriffs did come out and say, we're not going to enforce the SAFE Act. Unfortunately, what most of them did when they said they weren't going to comply was they just pushed the investigative duties onto the state police. So they may not have enforced it, but they helped enforcement of the SAFE Act. Like I said earlier, from my research, we've done some quests, we've done some research on, who's being charged and the demographics of being charged and where they're being charged. This looks like the SAFE Act, all it has done is become an add-on charge for the failed war on drugs. And so a lot of sheriffs aren't enforcing it. They're just using it as an additional charge if there's something else to make sure that something sticks.
Do you recall, wasn't the SAFE Act done rather quickly? Isn't that another issue that people had with that? Yeah. I don't know.
It was passed after Sandy Hook. So what happened is, after Sandy Hook, the government always looks for a reason to exist, or to make it look like they need to be in power. So what New York State decided was, after Sandy Hook, which didn't take place in New York State, they wanted to provide the false sense of security to New York residents that the government will protect you, as evidenced by what happened in the Parkland shooting, where the sheriffs actually hid while the kid was shooting up the school. And then the Supreme Court said, actually, police have no duty to protect you. The government can't actually protect you. It's up to you in the Second Amendment to defend yourself. So never let a good tragedy go to waste, the government decided that they were going to pass something to show that, hey, we're here, we're going to protect you. Keep paying your taxes. Keep pretending everything's okay. We're going to pass a security blanket act, kind of like a child. If you hide under the blankets, the monster under your bed won't eat you. The monster under your bed being, a shooting death, and that blanket being the SAFE Act. It's a facade, so the government can justify raising your taxes and taking away your liberties and your rights. Eerily similar to what happened during the lockdown. So it was just the government's ploy to make it seem like they're doing their best when they're really just doing nothing.
Certainly, it was quite controversial. Now the actual case, and we'll get to that in a moment. The actual case really doesn't deal directly with the SAFE Act, but with something a little bit before, as we'll talk when we talk to Jim in a second. So if you have a question, either to Duane or our next guest, Jim Ostrowski, please put it in the chat, and we'll forward it to the prospective guest, and they'll hopefully be able to answer that. So we'll be back in a moment with our next guest. Again, you're watching the State of Greater Western New York Report.
Through the mists of time, nature and man have both created and buried treasures beyond the imagination. With the ages, these riches slowly dissolve into mere myths until they are forever forgotten. But there are those brave souls who tirelessly cling to the truth, ever seeking to discover the undiscovered, to reveal what has always been there, to uncover the hidden gems of a land thought forsaken but loved by millions. 50 Hidden Gems of Greater Western New York. Discover the secrets in your own backyard. Buy your copy now at 50hiddengems.com.
Welcome back to the State of Greater Western New York Report. I'm Chris Carosa. With us today are two great guests, Duane Whitmer, who is the chairman of the Erie County Libertarian Party, just told us a little bit about the background of the New York State gun laws and various procedures that you need to follow, and maybe a little bit of why they were controversial when the SAFE Act certainly first came out. But the case that we're talking about right now, Jim Ostrowski will tell us a little bit more. He's an attorney. He's the one who actually has been dealing with this case. Jim, first, let's start out with just give us a little bit of background of how this case evolved and maybe what it's playing on what Duane just said about it being a little different than the SAFE Act.
Yeah, well, the case only involves the regulation of handguns, but the philosophy behind this law and the philosophy behind the SAFE Act are the same. It's sort of progressive big government pretending to solve our problems and blaming scapegoats when their policies fail. So we started the case back in 2015. I had a false start a number of years before that. After Heller came out, that's the Supreme Court decision holding that there is a right to bear arms. I had a group of people who wanted to file a suit, and we were ready to file, and then they found out some law firm downstate was filing it. That was the Kalkalski case. So after the SAFE Act came out, I looked up the Kalkalski case and realized that, well, that it only raised one issue, the proper cause for public carry, and we wanted to challenge the entire statute on actually 12 different grounds and file a sort of a more hardcore challenge based on what we call the government tyranny argument, that the purpose of the Second Amendment is to allow the citizenry to protect themselves from the government. So we did file that in 2015. It wound its way through the courts. There were some delays that were not our fault, but it took a while to get up there. And we finally got a decision from the Second Circuit that was negative, and we filed in the Supreme Court in February. Now, this is a motion for permission to appeal, and it's actually being heard today by the 9 judges in a private conference to which staff aren't even invited, and we expect a decision on Monday. So, but basically, we're challenging the New York pistol permit law, which treats having a handgun as a privilege, not a right. Heller says it's a right. Something's got to give one way or the other, and we're hoping that the court takes our case and also, for the first time, really clarifies what the purpose of the Second Amendment is. It's not hunting, target shooting, all these other things, recreation, and it's really not even primarily protecting yourselves from criminals, because if that's the purpose, then you go off into a certain mode of analysis. But if the purpose is to allow the people to be sovereign in a democracy and to reassume their sovereign powers when you get a tyrannical government, which has happened very many times in history, the fact that it hasn't happened here is proof that our argument is correct. There's a lot of mental confusion about that point. No, we haven't had the types of things that have happened in communist China, Russia, Cambodia, in Germany, because we argue we have a Second Amendment. So those people, if they're interested in reading the papers, if you can go to the Supreme Court and type in the word libertarian in the docket sheet and click on the first hit, you can read all our papers. It's all plain English. It's all laid out very clearly from start to finish. And so that's basically what the case is about.
Okay, well, let's talk about the impact that the case, let's say that it's resolved in your favor. What's the immediate impact to the everyday person, or who's going to be immediately impacted by it, as far as you can tell?
Well, if we win everything, we could have constitutional carry like they have in Tennessee. You walk into a gun store, you pass your background check, and you walk out with a handgun. We might get that. We might get if we don't win that, we might get a shall issue situation where you would still have to apply for a local permit, but the paperwork would be processed in a week. And if you pass all the qualifications, then you would be able to have a permit for to carry a handgun. So those would be the big victories, and there could be a number of lesser wins. But also, as far as the SAFE Act is concerned, the New York courts, well, the New York state courts themselves have completely ignored Heller and McDonald. So your odds of winning any sort of a Second Amendment case in state court are close to zero. Believe me, I've tried. But even the federal courts in New York have been applying a less strict standard that treats the Second Amendment like it's an inferior kind of right, in contrast to the First Amendment and other amendments which are given a priority. So if we do win, we expect the standard of review to change to make it much tougher to sustain a gun control law, and that we believe that would also overturn the SAFE Act as well.
There's an interesting
ultimately
question.
It would have to be challenged.
Yeah. We just got a question from the audience, which sounds kind of interesting. It's not really about the case per se. It's more about the process. How do you get the Supreme Court to review a case?
Well, you have to file a motion, and you have to show that your case involves a split in the circuit courts, or blatant violation of their precedent, or it's a matter of public urgency. We argued all of the above. There is a split on the proper cause for public carry in the circuits, and we did raise that issue. It's one of our 12 issues. We also argued that it's a matter of utmost importance. We saw in the last year that government can lapse very close to an outright tyranny, that government is incapable of providing safety in the face of massive rioting that we've seen. And it's really every man for himself. They couldn't even protect the federal courthouse in Buffalo during a protest because the Constitution in Boston glass got cracked. So we argued to the court that this is a matter of life and death. It's sad to have your First Amendment rights violated, but if your Second Amendment rights are violated, you might be dead. So we argued all of those different points, but it's very difficult to get in. They only take a handful of cases, but they've already taken the case involving New York State pistol and rifle on the proper cause to carry. And we argued very, very bluntly that, well, just because one group of people is represented by the biggest law firm in the United States, and we're represented by a solo practitioner, doesn't mean that we shouldn't have every right to get into the courthouse. So we threw every idea we could at the Supreme Court, and it's up to them to be receptive or not. We'll find out on Monday.
So is there any chance that they would combine these cases, or do they look at them one at a time?
That's what we asked for, and quite frankly, I said you should combine the cases because our argument is better. In other words, if you make the government tyranny argument explicitly like we do, it's sort of mentioned in the other case, but it's not. They don't lead with that. Then the argument for public carry just goes back to the Battle of Lexington. You can't resist tyranny, a foreign army that the people don't want ruling them, coming into your area to steal all your guns and cannon. You can't defend that right in your house with a pea shooter. You got to be out on the street, and you have to have a long gun, and a nasty long gun at that. So the government tyranny argument, which is our lead argument, fits very well into the notion that there is a right to public carry, and therefore we asked the court to consolidate the cases. And whether they do so, we also said, look, we know the court's calendar is coming up with this NYSERPA case. We'll meet any deadline you meet. We'll stay up all night. We'll get it filed. We always do. Even though we have limited resources, we'll probably have some more assistance if we get in the court, because people around the country I'm certain, will offer their support. But we really strongly urge them to consolidate, take both cases.
Well, what happens if they take the case? Then you have to go and argue, and when would that argument occur? Next year?
We file briefs. NYSERPA briefs are actually 2 weeks. hopefully they'd give us a couple more weeks after that. Their argument has not been scheduled. It could be really anywhere from October through the spring, I believe.
Now, is there somebody who argues in opposition to your stand, or do the judges just question you?
No, we're up against the New York Attorney General, Letitia James. So I imagine Barb Underwood, who's the Solicitor General, would probably go down there and argue it. But that's yet to be determined. So yes, there will absolutely be an opposing counsel. So
what are their biggest arguments in their favor right now, at least that you're aware of?
Well, that the Sullivan Act, the pistol permit law, was enacted for good reasons. It protects the public. The Second Amendment right is subject to all sorts of regulations and the discretion of the state. We're miles apart on how we view the Second Amendment. So it's really up to the court to say, is it a right or is it a privilege? It really comes down to that simple question.
So do you think that if the court takes the case and they make the argument, then what in essence they might be doing is defining or redefining what the Second Amendment is? Is that kind of what your take on this?
Yeah. Heller and McDonald were very limited decisions. They had to do with handguns in the home, I believe. So really what we need the court to say, look, the Second Amendment its purpose is to protect the sovereignty of the people in a democracy. And therefore, the people, you cannot make the people seek permission of the government that they need to protect themselves from as to whether they have the means of protection. So as a practical matter, what we need the courts to hold is that this is a fundamental right, and it can only be taken away under extreme circumstances. And you don't need a permit or a license. You don't need registration. You need to be able to arm yourself with the weapons that are useful in various contexts, and that would be a handgun, a shotgun, or a semi-automatic rifle. And that's what we need to establish.
So do you think that if the Supreme Court ended up ruling in your favor, would that eradicate the entire SAFE Act, parts of it? And I know it's not, you're not focused on the SAFE Act, but I just think the repercussions, what's the impact on the SAFE Act with regards to this?
Well, the SAFE Act really tries to take out of use certain long guns that have features that make them more useful. So the government already has huge built-in advantages. So if the point of the Second Amendment is to make sure the government doesn't get out of control, like it has, and we document this in our brief, in dozens of other countries, you can't say, well, the citizenry can't have the rifles that are most useful in defending themselves against tyranny. Again, there's two diametrically opposed views. And the gun control lawyers, they refuse to admit that government tyranny is even an argument, and the reason is because they have no answer to it, and they wouldn't even know how to deal with that argument if that was upheld by the court. But that is the case. The historical evidence is clear. The empirical evidence is clear that when you don't have a right to bear arms, you get collapsed democracies, you get political instability, you get coups d'etat. We pointed out in the supplemental brief in the court, Burma, Myanmar. We rest our case exactly what we said. Coups are caused by lack of civilian gun ownership. You get demonstrators shot in the streets, get mass murder on occasion, as we've seen history, and it's also in the brief. Because there's no counter argument to this, they ignore the argument. It's actually pretty funny.
Right. Well, Jim and Duane, thank you very much for appearing on this week's State of Greater Western New York. Thank you, the audience, who have asked some questions, or a couple of good questions. And if you'd like to be a member of the live audience to ask our guests questions, please feel free to go to stateof.greaterwesternnewyork.com and make that request to be invited as an audience member. This is a private request you get every Thursday morning, which gives you the link to that day's show. So if you'd like to be able to ask questions of our guests, and the only way you can do that is if you're a live audience member, then go to this place right now and sign up for a request. Jim, Duane, thank you very much. Thank you, audience. We'll be seeing you again next week. Bye-bye for now.